will resume the session. Mr. Foster.
Thank you, Mr. President. Professor Crawford, Secretary Eisenstadt. First, I know I speak for everyone when I thank all of you for the time and the attention that you've spent listening to the positions of the parties. And we look forward to your consideration of the evidence that you've heard. I'd like to begin by just addressing a few of the respondents' contentions in their opening statement and try to draw your attention to what we believe are the overwhelming facts that refute their contentions. The first contention the respondent made on its opening PowerPoint slide number 2 is that RDC did not keep its promise to invest. Respondent told you that Claimant never fulfilled its promise to invest. Respondent told you that after 13 years after Claimant, after the bid was issued and won by RDC, there is no modernized rail system in Guatemala. The facts are starkly different. What respondent didn't tell you was that as early as 1999, RDC's investment was significant and the modernization was well underway. In fact, Claimant had invested over $9.2 million by the end of 1999. Container traffic increased by 40.5% on average over the years that respondent, each year, 40.5% increase on average over each year that that Claimant operated the railroad. The first train ran in December of 1999. By 2006, Claimant had invested almost $20 million, had restored and operated 15 locomotives, 200 rail cars, and had restored over 200 miles of previously abandoned railway. The following are some of the images that respondent doesn't want you to pay attention to. The first, of course, is what this railroad looked like when FVG and RDC came into possession of it. It was literally in ruins. And in contrast, what RDC did was to install new cross ties to rehabilitate the railway. The evidence is overwhelming. Hundreds and hundreds and hundreds of cross ties. Bridges were restored. Heavy container traffic began. There had never been containers carried by this railroad before. Heavy steel transport began. RDC kept its promise. Now I'd like to just show you a piece. Unfortunately, it would take too long to play the whole video, but just a piece of the video concerning the first train, the train ride when Ferrovias had just restored the railroad. And I'd like to draw your attention to the terrain. RDC, of course, had experience in operating in precisely this kind of terrain. You can judge for yourself the condition of the equipment and the condition of the railroad. I think that's Mr. Sims' car that's being transported on the flat car. Does this look like the decrepit, accident-prone railroad that respondent tried to tell you was Ferrovias' product? More cross ties on the side. More cross ties that are being installed. Another restored bridge. Truly an engineering masterpiece. A retaining wall that was installed by Ferrovias. Thank you, Daniel. Respondent contends that claimant did not comply with its contractual obligations and that Guatemala feels misled. This was their second contention in their opening. Sir.
We saw some graphics from, I can't remember the name of the witness, one of the Guatemalan witnesses, showing track in disarray and so on. Do you have any comment on those?
The comment is that they're entirely misrepresentative of the actual condition of the railroad. You heard from Mr. Posner that this railroad operated for a year and a half without an accident just before Lesivo. A railroad that is in the condition that that witness tried to portray the railroad in doesn't operate that way. That evidence is simply inconsistent with the facts.
Just a clarification for counsel. I mean, the time taken by the tribunal questions is not counted against your time in this situation.
Thank you. In fact, RDC complied with its usufruct obligations. In fact, what really happened was that the respondent decided that it didn't like the obligations under the contract that into which it had solemnly agreed and set out to renegotiate them, demanding a $50 million investment, which was never required by the contract. And indeed, saying, as the President Berger is quoted, if you make the $50 million investment, we will sit at the table. We're not even going to negotiate with you until you do what we tell you to do.
Where in the record is that established?
The slides in each case, Secretary Eisenstadt, are the record references are marked on the slides. So you will be able to, when we finish this, you will be able to take these slides and you will be able to go through them and determine for yourself whether I'm misrepresenting the record evidence to you. And indeed, in an attempt to deflect attention from its extortionate demand that RDC invest an additional $50 million to rebuild the South Coast, respondent has invented out of whole cloth a purported contractual obligation to complete phases 2 and 3. Now, you gentlemen have heard the evidence and have seen the record, and you know that Contract 402 did not obligate or require FVG to complete Phase 2 or any phase after Phase 1 within any specified time frame. As Article 13 of Contract 402 says, the only obligation is to begin, and as you'll see from this quote that's in front of you, and offer railway cargo transportation services in at least one segment. So it's not even necessary under the contractual obligation for FVG to offer railway transportation over the entire segment that we're talking about. Over the entire phase, only a segment. FEGUA formally acknowledged FVG's compliance with the terms of Contract 402 by an official letter number 272-2001. FEGUA formally acknowledged that Phase 3 was impossible, and therefore FVG was excused. Official letter number 085A-2003. And as even Dr. Gramajo acknowledged when he testified before you yesterday, these official letters have never been revoked. As a result, they were in full force and effect the day Lesivo was declared. The day Lesivo was declared, FVG was in full compliance with its obligations under these contracts. Dr. Gramajo, even before his testimony, repeatedly and publicly acknowledged that FVG was in compliance with its restoration obligations. As you see here, Gramajo acknowledges the existence and validity of said notes. That's referring to the letters that affirmed FVG's compliance with the contract. He didn't like it, but he acknowledged FVG's compliance and never took any steps, as he testified to you. He never took any steps to revoke the letters, nor did he ever write FVG and contend FVG was not in compliance. Now, respondent's third contention is that claimant used this case as their golden parachute out of a failed investment. If that was the case, why did claimant try to convince customers and servicers to continue business relationships? If that was the case, why did claimant operate regular service until mid-2007, when traffic decreases and financial difficulties caused by Lesivo, forced the cessation of railroad operations? If that were the case, why did FVG continue to engage Mr. Cerny for bridge inspections after the Lesivo declaration? If that were the case, why did FVG vigorously fight the Lesivo declaration in the local courts? Why did FVG challenge the respondent in the press to reassure its customers and suppliers and try to influence the government to rescind the resolution? Why did FVG participate in the negotiation sessions after Lesivo to try to discover and understand the alleged problems with contracts 143 and 158?
Is it your position that your press statement was a reassurance to customers or a dire warning to them?
No, it is our position, and I think if you read the press statement carefully, it is our position that we were trying to pressure the government to revoke the Lesivo resolution. That was the whole purpose of the press campaign and the legal campaign that took place after the Lesivo declaration. We were doing everything we could to get them to take it back. Here you've got an example of claimant's efforts to convince its suppliers to continue to do business relations with FVG despite the Lesivo declaration. The respondent said these were perfunctory. They certainly weren't perfunctory. There you have the testimony of Mr. Jimenez. Is exactly what. So, and on cross. So they didn't really try to convince you in a hard way. If they did try to convince you, it was kind of perfunctory. And he said, no, not at all. Respondent's contention number 4. RDC made a risky investment on a bare bones budget. Respondent has told you that claimant made a very risky investment in 1997 to operate and modernize the railway, and that it did so at its own risk and expense. But what are the facts? RDC, as you saw in our opening statement, is a highly experienced rehabilitator and operator of railroads. Claimant's business model has created value in high-risk economic environments around the world. Indeed, claimant has lost money only in Guatemala. And in fact, RDC invested double what it was obligated to do. The contracts only require an investment of $10 million. As you know, RDC had invested nearly $20 million. Now, in fact, the facts are that respondents' own breaches inhibited claimant's growth. The South Coast route was not open because the respondent didn't have the money to move the squatters, despite their obligation to do so. You heard the testimony of Mr. Valenzuela, and you heard the testimony of Ms. Hernandez, where they said the problem was, and these are the quotes from their testimony, the problem was, they said, this is money that the government and FEGUA had to put in. They didn't have it. A large sum was needed, which the government did not have. The government did not want to continue the dialogue for making the large investment that was required. Respondent cannot rely upon its own contractual breaches to argue that FVG was not profitable. The fifth contention that they made, RDC knew the equipment contract was illegal. They told you in their opening statement. Again, you don't have to accept our word for it. They knew they were entering into an illegal contract, and public international law tells us one cannot profit from their own misconduct. That's what they told you. But in fact, FVG entered into contracts 143 and 158 at Fegua's request. There's no credible evidence that the time contract 143 was entered into that FVG understood or believed that the contract was illegal and void, or was ever informed by Fegua that it considered the contract to be illegal and void. As Mr. Sin testified, Fegua's lawyers were intimately involved in drafting both contracts 143 and 158. And if you will remember, when Dr. Gramajo testified, he was specifically asked who drafted the contracts. I think you asked him, Secretary Eisenstadt, and his response was, I don't know. Well, the only evidence on that subject is Mr. Sin's evidence, and he testified repeatedly that Fegua's lawyers were intimately involved in the drafting of the contract. Furthermore, both Mr. Franco and Dr. Mayora testified that because Fegua is an autonomous entity, presidential approval and public bids were unnecessary. Why would RDC think there was something wrong with the contracts when eminent lawyers don't believe that any of the contracts needed presidential approval or a public bid? Any asserted technical illegalities were fully within the exclusive control of the respondent to resolve. There was never anything really to negotiate. Claimant couldn't remedy the lack of presidential signature. Claimant couldn't force the respondent to hold further public bids for the equipment usufruct. These were all things within the control of the respondent. Fegua's negotiation points all deal with issues other than presidential approval or a new bidding process, and many involve issues under Contract 402. Look at the exhibits that we've cited here. You will see, and as you just heard this morning from the witness, it was a comprehensive deal. He said the contracts were intimately intertwined. We were looking for a total resolution. That's their testimony. Further, as you saw yesterday when you saw the Dr. Gramajo's notes on the draft new contract for 143, his notes didn't have anything to do with obtaining presidential approval or a new bidding process. And there's no documentary evidence that those notes were ever sent to FVG anyway. Indeed, the negotiations to amend the contracts to remove so-called technical irregularities were a sham. The issues which ultimately prevented agreement had nothing to do with presidential approval or a new bidding process. Remember Dr. Gramajo's testimony when I showed him paragraph 20 from his statement where he set forth the items that prevented agreement. They were return of historical railway items, cannibalization of railroad equipment, and valuation of inventory, nothing having anything to do with the purported technical irregularities of the contracts. Dr. Gramajo even testified that Fegua did not pursue a new bidding process because it was afraid that someone other than FVG might win the bid. Do you really believe that? They didn't pursue a new bidding process because the entire issue was just a concocted claim to leverage contract concessions from FVG. At all times, Fegua's legal department considered contracts 143 and 158 to be in full force and effect, and canon payments were made and accepted pursuant to that contract. You saw yesterday during Dr. Gramajo's testimony the Fegua internal legal staff's opinion where they said contract number 143 as amended by contract 158 is currently in effect. And extremely importantly, they said the contract number 143 which is currently in effect, it is under the terms of this contract that the usufructuary is using the railway equipment. Their legal staff considered FVG's use of the railway equipment to be pursuant to contract 143, which they now try to tell you there was something wrong with it. Furthermore, if you look at that same legal opinion, you'll see where it says FVG has delivered to Fegua, 596,000 quetzales. And as a result, it renders the opinion that Ferrovias is up to date for the payment of fees for the use of railway equipment, which, as we've just shown, they were up to date in payment of fees for use under Contract 143, which their own legal department says was in full force and effect. Respondent accepted FVG's performance under the use of her contracts, including resumption of railway service and millions of quetzales in canon payments, without a hint of contention that FVG was in default. Both Mr. Carrillo and Dr. Gramajo testified that they took the canon payments without reservation, without any hint that they were going to later contend that somehow or another those contracts had not been in effect. Indeed, respondent thus is stopped from contending that FVG was in any way deficient in its performance. Indeed, the tribunal has already ruled, and I quote from paragraph 145 of your second decision on jurisdiction, where you say, who took the initiative to sign a new contract is irrelevant to the tribunal's conclusion. Fegua and FVG were faced with a de facto situation which they tried to reflect in Contract 143, and Fegua benefited from a 25% increase in the canon stipulated in Contract 41. Their contention number 6, FVG would have never signed an additional commercial lease during the life of the usufruct. As you know, when Dr. Spiller was testifying, he responded to Secretary Eisenstadt's question, are you assuming that there would have been no additional easement contracts and no additional commercial business? And he said, right. That's his assumption. Can anyone say that that is a reasonable assumption? I don't think so. And indeed, the facts are industrial squatting is rampant post-Lesivo. Electricity companies have lined the entire right-of-way with power lines from coast to coast. To say this right-of-way is worthless is simply preposterous. And here are the pictures. You've seen these before. I'm not going to dwell on them, but these are power lines over every square foot of this right-of-way by 4 separate companies. And
can you just elaborate on that? Are you today receiving compensation from all 4 companies?
None of them.
Have you sought to do so?
We have not. We thought it was a futile act, Secretary Eisenstadt. Our experience with everyone we have dealt with after Lesivo is you're a dead man walking. We are not interested in doing business with you. And indeed, Planos y Puntos, as you understood, when we had an extension of their contract in writing, ready to be signed, said absolutely not. We're not going to do it. We think that to require us to have gone out and sought to collect money from those people would be an unreasonable requirement.
Were there any power lines before Lesivo?
I'm going to turn to that in just 1 second. You ask us, as you can see, there's tons of pictures of these power lines. Most of the power lines were installed after Lesivo. Remember Mr. McSwain's testimony. He said he examined the entire right-of-way except Tucunuman in mid-2007, and most of the power lines were not there. The pictures you have just seen were taken from 2009 to 2011. So the undisputed, and they offer no testimony to the contrary. Lord knows, Fegua has ample ability to offer contrary testimony if there was possible to offer truthful contrary testimony. They didn't because they can't. They know, as these pictures prove, in connection with Mr. McSwain's testimony, these power lines went up after Lesivo. Now, you ask the question, who are the industrial squatters? As you saw from the pictures, they are Dioxa and Diorsa, who are subsidiaries of a Spanish company, IGSA, formerly 100% government-owned, now 14% government-owned. IMSA, the municipal electricity of Zacapa, and INDI, which is owned by the government of Guatemala. Thus, the government, through INDI and its partially owned company, IGSA, is the principal industrial squatter. Second question, can Lesivo be negotiated away? You heard yesterday, possibly from Mr. Mariora, possibly, but not in this particular situation, because the declaration of Lesivo has been predicated on alleged illegalities in the contract at issue. Thus, he concludes that the way in which this declaration of Lesivo was issued, this particular situation, the possibility of entering into negotiations conducive to a settlement became closed door, was made impossible. And your third question, can the President be held liable, personally liable for failing to declare Lesivo? Dr. Mayora told you neither the President nor his Cabinet would be found liable for failing to declare Lesivo because it was a discretionary act, not a mandatory act. Now, I'd like to talk. Yes, sir.
We've heard a great deal about the President's liability. In actual experience, how often have Guatemalan presidents been held to be financially liable for decisions?
We're not aware of any, ever, for any decision, whether it was Lesivo or any other decision that a Guatemalan president has made. I think some of them have had some more severe consequences for some of the decisions they've made, but liability hasn't been one of them. Now I'd like to turn to the elements of proof. As you know from the discussion of the law in our opening statement, there's a substantial overlap of the elements of proof as to the specific claims. And here's a chart which depicts our contentions as to the nature of that overlap. Thus, for purposes of this closing, we have therefore organized the evidence around the elements of proof, which you, as a result, can use in your consideration of each of the various claims. The first element of proof is a substantial, lasting economic harm to FVG. And as you heard the evidence, the Lesivo resolution made FVG too risky to do business with on an ongoing basis. There was a dramatic decline in the use of the railroad for freight transportation, a 35% decline in the first 6 months of 2007 as compared to the first 7 months of 2007 as compared to 2006. Reversal of market share gains versus trucking. Withdrawal or denial of credits from suppliers. Failure to be able to secure a single additional lease or easement on our right-of-way. Prospective commercial tenants consistently cited the Lesivo resolution as the reason for backing out of negotiations or preliminary agreements with FVG. And while the print is awfully difficult to read at the bottom of the page, you will be able to go through and check the testimony to see where each of these elements is amply proven. Theft, vandalism, and squatters dramatically increased after the government's repudiation of FVG's usufruct, making it impossible to return to the status quo ante. Just between the Lesivo resolution and early 2009, 65 kilometers of rails and track materials, along with cross members of 3 major bridges, have been stolen. They don't exist anymore. This railroad is never going to reopen because of the Lesivo declaration. Furthermore, the Contencioso Administrativo proceedings that are used by the government to confirm lesividad offer no reasonable prospect of a ruling within any reasonable time frame. Of 17 known cases in 2 decades, only 2 have ever been decided, one of which was conveniently released just prior to this hearing. In October 2011, you heard Mr. Franco, FVG's lawyer, say he went to court, and a court official told him that the court had been instructed by the government not to issue a ruling while this arbitration was pending.
I'm sorry, that misstates the evidence. I refrained myself, but Mr. Franco never said that there was an instruction by the government. That is simply not in the record.
Well, you can check and see whether I've misrepresented. I'm telling you I haven't. In fact, I think we're going to see the quote on another slide, so we'll just see exactly what he said. Again, you heard Mr. Jimenez, who testified. He was the gentleman who moved the containers from the railroad to the customers. He said he quit doing business. He couldn't take the risk anymore. Mr. Sin described in detail the effect on the business. Second factor, or second element of proof, no payment or offer of compensation. There's never been an offer of payment or compensation. And contrary to respondents' claim, there's no private party right to assert a counterclaim or claim for compensation against the government in the proceeding to confirm the Lesivo decree. Indeed, the Attorney General acknowledged that the government used the Lesivo process to avoid paying compensation. And you see the quote from the Attorney General on the next slide. Now, let's talk about the frustration of RDC's legitimate expectations. Certainly, it was a legitimate expectation of RDC that the government-structured railroad usufruct complied with Guatemalan law and had the government's backing and blessing. I think the Congress promptly approved Contract 402. FVG had won all the necessary public bids. Overseer Porras, as you heard him testify, urged presidential approval of Contract 41 numerous times. He said, I don't have the faintest idea why he didn't approve it. He's a lawyer and an MBA who negotiated the usufruct contracts, and he knew of nothing illegal or harmful to the interest of the state in Contract 41. It met all the negotiation and bid requirements, and that's why I myself, he said, submitted to the president to be approved. VEGUA promptly negotiated an agreement, a letter agreement for FVG to have the use of all equipment on terms exactly like Contract 41. FVG and VEGUA negotiated replacement contracts, and as we have seen, VEGUA accepted payments under Contract 143. The VEGUA overseer had independent legal authority to enter into those contracts, and VEGUA's legal department acknowledged that the contracts were in effect. Just yesterday, respondents' expert said that no less than 4 VEGUA overseers were acting illegally. To go to Professor Crawford's point about fraud, surely FDC had the right to believe that they were acting legally. And their actions, the government's actions in inducing RDC's performance by the expectation of legal action, where they now say they're relying on it being illegal, must constitute fraud. By accepting performance and payment without protest, respondent reaffirmed that the contracts were in effect. The usufruct had a 50-year term. Surely RDC was entitled to rely upon the length of the term in establishing and formulating its business plan. Now, you've got quotations here from senior VEGUA officials admitting that there was nothing weird or wrong about FVG's contract and that FVG had honored its contractual commitments.
One gets a certain impression that after 6 or 7 or 8 years of operation, the railway really wasn't going anywhere. Now, I say that's an impression, and it's not an impression which I've definitively formed at all, but I'd just be interested in your comment on that.
Well, I think the railway was...
if I may say so, it appears to have started well, but doesn't appear to have taken off.
Well, indeed, by 2004, the railway, if you include VEGUA's contribution to the trust, which they should have made, the railroad was cash flow positive. So I think it's very difficult to say that the railroad wasn't headed in the right direction. Furthermore, the existence of the extension to the Planos y Puntas right-of-way agreement, which was frustrated at the very last minute by Lesivo, is a further indication that the railway leasing activities were beginning to take off. And now we have the picture of the entire right-of-way, the demand for that right-of-way. Admittedly, the demand may be, at least in part, because they're not having to pay.
Exactly.
But the fact is, Professor Crawford, when somebody invests millions and millions and millions of dollars in poles and wires, and when that is, as you heard the evidence, that is the most convenient, the best way to get from point to point because it's uninterrupted, they're not going to remove those poles. And when it's the government whose entities are the principal industrial squatters, for them to come in here and say that somehow they can rely on their not paying rent in order to show that FVG didn't have a bright and promising future, that's just plain wrong. They're neither legally nor morally entitled to come in here and argue because they're not doing what they ought to do, that that's the reason somehow that FVG was not successful.
Let me just follow up on Professor Crawford's questions. From what we've understood, the actual profits from the railway operation would have been a relatively minor part of the expected rate of return, and that most would have come from the leasing of the right-of-ways. Is that an accurate statement?
Yes, sir.
If that's the case, why did the leasing part seem to get off to such a slow start? That is, one would have thought that from day one there would have been an aggressive effort while you were trying to get the railroad operation going to get this right-of-way leased, and it doesn't appear that that started until well into the process.
Well, actually, a lot of the leases were early in the process, and I think if you look at the evidence, what you see is, and Professor Crawford alluded to this, there was a very good start. The railroad got operating again. There was some leasing, and then the disputes began to arise that were fomented by Dr. Gramajo. The whole concocted bit about the alleged illegalities of contracts 143 and 158. Then the dispute began to arise over the removal of squatters and the payments into the trust fund. And then the arbitrations were begun by Ferrovias in order to try to remedy that situation. And then the dispute arises about whether or not they should open the South Coast route. What I think the direct answer to your question is that there was a substantial diversion of FVG away from its focus, not only on leasing, but actually a diversion of its focus on even on operating the railroad because of the activities of the government. And they want to come in here and blame that on FVG.
There was a period in that middle phase before Lesivo where there were a series of disputes with the government, but it didn't seem that that had any particular commercial implications in terms of the success of the railway as an enterprise with its both elements. I mean, isn't there a concern about that intermediate period?
Well, I don't think there should be, because despite these diversions, the business was moving steadily to profitability, which it actually attained, and would have been profitable again in 2005 if it hadn't been for Hurricane Stan. So I think what we have here is a business. Railroads are not known for being instant cash cows to start with. I don't think Mr. Buffett bought Burlington Northern Santa Fe counting on the money he was going to get from it the first year he owned it. They're not known for being immediate cash cows. These are long-term projects. But what we have here is a relatively short period of time in which the railway was proceeding to good cash flow profitability, and I believe that if it hadn't been for the distractions, and considering that the demand that there was for the railway right-of-way, that the leasing activities would have been extremely successful. In fact, I doubt that FVG would have even had to pursue them. I think they would have been being pursued by people who wanted to use that right-of-way. Now, turning to the third element of proof, no credible public interest justification for the Lesivo resolution. No public purpose was ever stated in the take it or leave it settlement agreement. No public purpose was invoked in the Lesivo resolution other than a general invocation of public welfare. No public purpose was invoked in the Lesivo court proceedings other than, again, a general invocation of public interest without specification. Nowhere do these government documents state that the Lesivo action was undertaken to uphold the rule of law or for the common good of the citizens through the development and rehabilitation of the railways, transport and use of rail equipment, as the standard, I think, has now been articulated in the most recent Lesivo decision of the Constitutional Court. Moreover, as we've seen, President Berger himself publicly stated that the real intent was to get the $50 million to open up the South Coast route. And you heard today Mr. Marroquin testify about the High-Level Railroad Commission, and he said it was to make viable the whole question of the railroad. He conceded that many issues were discussed in the High-Level Commission. He conceded, he said, the contracts were three. In effect, one was tied to the other. He said the purpose was to make viable rail operation. A lack of rail operations in the entire country, that's what was sought. They wanted a revised rail operations plan. What does any of this have to do with technical illegalities in the contract? The technical illegalities were never the focus of anything the government did. They were always trying to achieve another objective which they had not achieved through the contract negotiations.
Do you accept there were technical illegalities?
Sir?
Do you accept there were technical
No,
illegalities?
sir. No, sir. We do not believe that, and as Dr. Mayora testified, that there never was a requirement for a public bidding on contracts 143 and 158, and there was no requirement for presidential approval of any of the contracts, ever. Then we turn to denial of due process. We've talked about this a lot. I'm not going to go back through it in detail. You know what the lack of due process in the Lesivo proceeding is. There's not even a semblance of anything like due process as it is understood in the major legal systems of the world, and I believe that that is the standard for due process under customary international law.
Excuse me, I think, although this is not an issue you may be able to address here, there was some indication in the documents that there were a number of other countries in Central and Latin America and perhaps in Europe that have something similar to a Lesivo process, and it would be useful, I think, for the tribunal to know whether in those other countries there were any so-called due process built into the administrative stage as opposed to the subsequent phase with respect to courts. I don't know whether you can testify to that now, or you could perhaps put that as one of the issues that both sides might address.
I'd love to testify at any time, but the one...
So long as I can cross-examine, Alan.
That's a deal. The one that I remember, and it's been a long time since I've looked at them, but the one that I remember is, I believe I'm remembering accurately, is the Spanish Lesivo process. And my recollection is on two respects. I remember two things that I think distinguish it completely from the Guatemalan system. Number one, there is a procedure for hearings before the invocation of Lesivo, and number two, there's a provision for compensation. I think there are undoubtedly other things as well, but you're right, Secretary Eisenstadt, it would be more appropriate for us to address that issue not on my memory, but on the basis of citations to the statute. Now, here's the quotation from Mr. Franco that there was some question about earlier. He says, Yes, yes, oh, yes, yes, yes. The thing is, that this is quoting the court proceeding, the court official. Yes, yes, yes. The thing is, as regards to that proceeding, on that proceeding, there is international arbitration. And then Mr. Franco said, yes, that's correct, but the international arbitration has absolutely nothing to do, nor does it stand in the way at all of there being a ruling and a judgment in this proceeding. And then the court official said, yes, but that's the instruction we have.
I mean, what weight do you expect the tribunal to give to an unidentified official who we have no basis to know was speaking on behalf of anyone other than himself?
Mr. Franco named the person who is a court official. Apparently, he is the one who was in charge of this particular proceeding. And in conjunction with the fact that the government says, oh, well, we've asked for a decision twice. It's been 5 years. They had 6 months under the statute to, if you add up all the time periods under the statute, they had 6 months to render an opinion, and it's been 5 years. I would certainly ask the tribunal to draw the inference. And I think it's a good inference, particularly when in consideration of this evidence, the inference that it's merely, the decision is merely awaiting the resolution of this case. And then I think I can predict pretty confidently you'll have it. Now, I'd like to turn to the national treatment issue, the three-pronged test. The first, of course, is the like circumstances, and we've offered evidence that Mr. Campollo operates in the same business or economic sector as FVG, that is railroads and real estate. You heard about his railroad. It hauls more tonnage than Ferrovias ever did. Mr. Berger admitted Mr. Campollo, by means of Hector Pinto, had a series of meetings with Ferrovias staff in order to reach an agreement to exploit the right of the railway with a view to support his Ciudad del Sur project. And Mr. Campollo himself acknowledged that his interest in the railway was based in principal part on the benefits it would bring to his project. The Desarrollos G offer, and I would ask you to infer that if Mr. Berger admits that Mr. Campollo, by means of Hector Pinto, had a series of meetings, I would ask you to infer that when he presented, when Mr. Pinto presented the Desarrollos G offer, he was acting again on behalf of Mr. Pinto, and you saw that the cover email for that offer sends a copy of it to the son of Mr. Campollo's personal lawyer. Now, I'm not going to go through all of these things that Mr. Pinto said and did on behalf of Mr. Campollo. I would just ask you to read the timeline that we gave you in the opening statement but did not have an opportunity to look at in detail. Read the timeline and see if you can come to any conclusion other than the fact that Mr. Pinto was, in fact, acting on behalf of Mr. Campollo, that Mr. Campollo not only wanted to compete in the same sector as FVG, Mr. Campollo wanted FVG's concession, direct competition.
May I just ask, because again, in terms of understanding your contention here, if in order for this issue to be relevant of whether Pinto was acting for Campollo, which Campollo said he was not, and Pinto, of course, is not alive, do we first have to make a judgment that they were in effect in a like circumstance, that they were actually potential competitors in competition with each other? That is to say, if we don't make that finding, then is any of the Campollo issue relevant?
I think it's 180 degrees the other way. You make the determination whether or not they were in the same sector in part upon your decision as to whether Pinto's statements are attributable to Campollo. But even without those statements, you can still come to the conclusion that they were in the same business from the undisputed proof about Mr. Campollo's railroad and the undisputed proof about his Ciudad del Sur real estate development.
But I mean, on the railroad, this was in another country. which was not in direct competition with RVG. It was apparently a very small line, and it didn't appear to be a principal part of Mr. Campoglio's business, whereas for RVG this was their main business. How do you respond to that?
They don't have to be direct competitors to begin with. They have to just merely be, the test is that they have to be engaged in the same economic segment. And I don't think it makes any difference whether what country they're in the economic segment, because what we are saying is that here's a person who was in the same economic segment and who was seeking to obtain RDC's usufruct. So I think that you can come to, as I say, I think you can come to that conclusion without relying upon what Mr. Pinto said, but I think it is easier for you if you do connect his statements to Mr. Campoglio. Now, the second prong of the test is that the intended discriminatory effect was substantially to deprive RDC of its expected economic benefits under the usufruct. Certainly, the take-it-or-leave-it settlement offer required FVG to surrender unrestored railway sections in which other investors may be interested. We, of course, contend that that's a code phrase for Ramon Campoglio. And indeed, Ramon Campoglio was the only interested investor in the South Coast corridor who was identified by a government official in the March 2006 meeting with the president. That evidence is, of course, they say that it never happened, but the simple fact is that Mr. Posner has contemporaneous notes before he ever had a clue that this arbitration was going to ensue. He's got contemporaneous notes that say that Mr. Campoglio was identified as the other investor at that meeting.
If the purpose was to give this railroad to Mr. Campoglio, I mean, we're now in 2011, you've left in 2007, would one not assume that that might already have happened?
I wouldn't. If I were advising the government of Guatemala, I would tell them that the last thing on earth they should ever do is to prove the other side's case by giving the railroad to Campoglio until after this is over.
Didn't seem to be particularly interested in the railway.
That's what he said. And what would you expect him to say? Would you really expect him to come in here and say, "Oh yeah, I wanted to take over the railroad. I was conspiring with President Berger the entire time to do it"? No, this is obviously not a case in which there's ever going to be any direct evidence. But as we know, circumstantial evidence is just as valuable in proving a fact as direct evidence is. The issue is whether or not you credit it. And you may say, well, it's easier to credit the direct evidence. But the simple fact of the matter is there's not ever going to be direct evidence because the butler is not going to confess that he did the murder. The government has never identified any other interested investor. Who were they talking about? Why didn't they come to you and say, "Oh yeah, when we said other interested investors, we were talking about Smith and Jones. We weren't talking about Campoglio. And here are Smith and Jones who are going to tell you that they were interested." But they haven't done that. And the reason they haven't done it is because the other interested investor was Ramon Campoglio. The third factor is, and I believe you've already answered this one in your second opinion, on jurisdiction, when you concluded the respondent used the lesivo process as an element of pressure to achieve other results which were unrelated to the lesividad declaration. That confirms that there's no nexus between the issuance of the resolution targeting FEG and rational public policy. Now, we've got some slides in here concerning some of the evidence about Mr. Campollo's railroad and how it's similar to FVG's. I'm not going to go through it with you, but as Mr. Duggan said, when it looks like a duck and it walks like a duck and it quacks like a duck, it's a duck. Now, the next factor is arbitrariness falling below international standards. You have heard repeatedly from the witnesses that no one can explain to this day why Contract 41 was not signed by the executive. No one can, and indeed, Overseer Paras said it could have been signed by any president. It wasn't necessary that it be signed by the president in office at the time. And if you remember the exchange, he went through all the presidents since that time. He left out President Berger, and I had to remind him that would President Berger have been able to do it? And he said, yes, absolutely. President Berger could have solved this entire problem. All he had to do was sign the contract, and it's over. And there are lots of other points here concerning arbitrariness that falls far below international standards. And
I believe that your expert witness himself, Mr. Mayor, when we asked that question yesterday, may have said that he thought that under the circumstances the president may not have been able to sign 143 and 115.
He did. I believe he was saying. If what I understand about his testimony, I wasn't here, but it's been described to me. I believe what he was saying was that he didn't think it was necessary. It's clearly his opinion that presidential approval is not necessary for these contracts. And I think that's what he was referring to yesterday. Okay. There is a large number of items here that we'd like to draw your attention to about arbitrariness falling below international standards, and the record in documents, statements, and opinions and hearing testimony is replete with the proof of those elements. And as you know, even Mr. Aikenhead agreed with regard to some of these. That what, as Arbitrator Eisenstadt asked him, you're saying you were seeking a global agreement on the 5 different items in the minutes. That was the goal, and he said the ultimate purpose was that, although we could have had intermediate objectives. Now, turning to bad faith. Again, we've got a large number of items here with a lot of evidentiary support behind them. We believe that you've seen amply demonstrated to you that throughout, the goal of the government was to renegotiate the terms, not to fix the illegalities. They were not proceeding in good faith. Let's turn briefly to failure to provide full protection and security. You saw that there has been a sharp rise in squatters, theft, and vandalism after Lesivo, whereas the respondents' efforts were directed merely at identification and documentation of third-party interference with FVG's rights. I showed you in our opening statement the pie charts of the difference in quality of the actions that they took before FVG got the concession, when they were concentrating on indictments and criminal prosecutions, versus after Lesivo, when it was paper pushing. Again, Mr. McSwain's evidence concerning it's set forth in detail here that the squatters, the industrial squatters, came after Lesivo. And indeed, Figueroa's chief engineer, Mr. Samoya, admitted that the influx of squatters increased after the Lesivo declaration. Now let's turn briefly.
Excuse me, are you contending that this alleged failure to provide full protection and security existed before Lesivo or only after?
Well, I think we we are limited in this proceeding to contending that it existed afterwards. But if you look at the chart that I showed you in opening statement of the actions of the government, you can see that they took virtually no actions whatsoever during between the time that we got the concession and the time of Lesivo. But we're not arguing that inaction during that period of time is a violation of CAFTA. What we are arguing, however, is that the government cannot come in here and tell you that FVG was unprofitable when one of the reasons, or a large portion of the reasons, that FVG was not having as great a profit as it could have was its failure to pay into the trust fund and its failure to remove squatters, which caused all sorts of operational problems. That they can't do. Now, we talked a lot in the opening statement about the need for a full reparation standard, which includes, we argue, includes both the recovery of sunk cost and lost profits. Dr. Spiller admitted when he testified before you that the result of his methodology would be to assign the exact same amount of damages for a legal act or an illegal act. There's no distinction in the way that his damage methodology operates. There are many examples which we cited to you. I won't go through them again in the literature and in the cases in which both sunk cost and lost profits are recoverable. And now I'd like to turn to the proof of lost investment. Now, Dr. Spiller, remember, he conceded that the net cash contribution method, which is essentially recovery of sunk cost, is appropriate when the expropriation takes place in close proximity to the investment. I didn't put the citation on this slide. If you would like to make a notation of it, that's in the first Spiller report at paragraph 75. Not 74 is noted on the slide. That's a typo. Dr. Spiller admitted when he testified before you that RDC was still making investments, that it had made investments throughout the entire period, both before and after Lesivo. He admitted that before he saw where my questions were going. And then he proceeded in some of his, I actually, out of curiosity, had someone count them. He managed to get out over 7,000 words in a little over an hour. I think that's bound to be a record for testimony. In any event, claimant's proof of sunk cost remains unrebutted in these proceedings. The respondent has not, they've contested our entitlement to sunk cost, but they have not, either through cross-examination or expert witness, contested the numbers that make up our sunk cost. They didn't even want to cross-examine Mr. Hensler and Mr. De Leon, who presented the evidence of sunk cost. And that evidence was that the sunk costs are approximately $19 million plus another $1,350,000 in shutdown cost. And you know that when you operate the model on the weighted average cost of capital, and you bring those sunk costs to the value, to their value at the end of 2006, they come to $42.9 million in sunk cost. And of course, the respondent does contest the WAC number, but as we discussed before, you'll be able to manipulate that model yourself. If you don't like it the way it is, you can come to your own number and for WAC and put it into Mr. Thompson's model. Now turning to the future profits, it was notable that when Dr. Spiller testified, he would accord the same value to a company in which there had been no investment, but which had reasonably expected future profits. I give you an example of a McDonald's franchise for that. No investment at all, and he says, okay, it's worth X. Then he says a company where there had been a substantial investment, but with no operating history, but reasonably expectable future profits, it's just worth X also, even though they made a huge investment. And then a company that had been a substantial investment with an operating history and reasonably expected future profit, he says that's worth the same thing as the other one. It makes no sense whatsoever how three businesses in totally different circumstances can be worth exactly the same thing to Dr. Spiller. Now, respondent found it astonishing, they told us, that Claimant's experts believed rail revenues were going to increase. Well, what's really astonishing is that FVG attained container compound growth rate of 40.5% per year on average from the time they started carrying traffic. Real estate income, we contend, we've already talked a little bit about this, we contend it would have increased dramatically without Lecevo because of the number and extent of electric utilities alone, which use the right-of-way. And we've got some charts on that. And when you consider this, please consider the testimony you've just heard from Mr. Marroquin, that the Mesoamerica study, upon which respondent relies so extensively, didn't even consider real estate income. Now, you've got two charts here, one of which shows the existing rentals and projected right-of-way leases versus commercial leases. The next chart merely adds in one other factor, and that adds in the income from Tucumán so that you can see how it affects the slope there. Dr. Spiller asserts that because FVG had experienced losses, there can be no certain proof of future profits. Well, I would just ask you to consider, from your own knowledge of the business environment, the number of companies that there are who make enormous investments and show operating losses for a considerable period of time, and then literally shoot into dramatic profitability. I'm not going to go through the weighted average cost of capital computations again. You saw those before. I'll just give you a summary. Remember the argument over the
Just to go back, can you?
Yes, sir.
Can you summarize? I mean, we saw the chart of the projected incomes from the existing leases, but what proof do we have that there would have been this acceleration of profits? What potential contracts were there? What people were you talking to that were near making a decision that would give us any basis to determine that this takeoff in profitability would occur?
The ones that were closest to fruition were the Planos y Puntos extension of its right-of-way lease, 37 kilometers at $3,200. The principal importance of that is the validation of the rate. The second is, of course, the Girona parking lot, where there were people who were interested in not only in having a parking lot, but in building an office building. As you know, that parking lot is the one that the Attorney General's office sits next to. And those cars that you saw in the pictures are people who work in the Attorney General's office. Again, the government's a squatter. In fact, a little piece of his building sticks over on that property. But there's tremendous demand there. You had the Unisuper plans to open the supermarkets, the shopping centers actually, starting in Zacapa and extending into 7 or 8 of the other major stations. Those three different projects were literally on the cusp of fruition prior to it. The final piece of evidence that I think we would point to particularly is the actual existence of the demand for the right-of-way as a result of the industrial squatters. And surely the government can't come in here and say that companies which it owns or in which it has an interest would not have been willing to pay rent for the lines that they put up in that right-of-way. So that's, I think, the proof we'd ask you to look at. Okay, I just want to just point out the three arguments that there are in connection with the weighted average cost of capital. One has to do with the data that's used for the risk premium, and that's the 10B versus the 10. And as Dr. Pratt points out, the data that he uses already contains the distressed companies that Dr. Spiller would have you concentrate on. The second is the cost of debt. FVG actually obtained its debt financing from RDC, and therefore RDC's rates should apply. As Dr. Pratt explains, the cost of debt is not a built-up number. It's an actual number. You look at what the company actually did, and it borrowed its money at 7.8%, not the 18.67% that Dr. Spiller posits. And then the blending is based on revenue streams rather than just an arbitrary selection of 50-50 split. I'd briefly like to show you one thing. Dr. Spiller gave a bond, example of a 5-year bond in his report, which he said demonstrates that there is severe double counting in our amortization methodology. If you go through that bond and you look at this little sheet that I've prepared for you, you'll see that when you actually look at the amortization, there's only a 13.41% quote, as Dr. Spiller would call it, double counting. Thus, his fanciful assertions that this is a terrible amount of double recovery for FVG are simply not borne out. Also, as you heard from his testimony, his methodology of grossing up the amortization using the weighted average cost of capital, as a matter of mathematics, just brings you back to where you started. You have nothing left but future profits, and you haven't recovered anything for sunk cost. And if you gentlemen decide that in the case of the illegal action by a state, that something more than just either, on the one hand, sunk cost, or on the other hand, lost profits are appropriate, I would submit to you that the proper result is sunk cost plus lost profits with the sunk cost amortized over the income stream of the lost profits. Now turning to business termination and wind down costs, again, it's about $1.35 million. There's no attack by the respondent on the numbers. They attack whether or not we're entitled to it because they say that that a lot of it was spent on operations. Well, of course some of it was spent on operations. FVG had long-term contracts which it was obligated to complete. Starting a business costs money, and winding it down costs money. And it cost $1.35 million to respond this one down. On prejudgment interest, that's, I think, going to be an issue of law for you as to whether or not it should be compounded or not. We believe that the current authorities are overwhelming that prejudgment interest should be compounded. One issue is what the rate should be. One of your alternatives is to consider, looking at the sunk cost, that this has been a forced loan, a coerced loan to Guatemala, and that Guatemala should therefore pay the 9.34% that is allocable to the times when Guatemala borrows money. That then brings us to some options that you have before you. The first is to award sunk cost plus lost profits minus amortization and then minus mitigation. That would bring you to $63,778,000. The second option is to award lost profits without sunk cost, and that lost profits of $30 million minus mitigation would bring you to $27,361,000. The third option is return the claimant to the same position as if the investment had not been made, and that is an investment of $19 million brought up to current value by 12.9% WAC, plus wind down cost minus mitigation. That brings you to $41,589,000. Another potential, a variant on option number 3, is to use, instead of using the WACC of 12.9%, to use the coerced loan theory at 9.34%, which would bring you to $33 million. I would point out to you, however, that if you were to choose the coerced loan theory, that I would submit that you must award legal costs and expenses, because the only way that you remedy a coerced loan, in order to recover their coerced loan, RDC had to hire lawyers and spend money. So an essential part of the coerced loan theory is the recovery of costs and expenses. Regardless of that, however, we ask you regardless of your which way you go, we ask you to award RDC its cost and attorney's fees in this case, because as a matter of justice, this is a case in which the claimant should not have to bear its cost of collecting its money. Now, finally, just as a last comment, I'd like to recall to you something that Mr. Thompson said. Here, Mr. Thompson is one of the world's foremost experts on railroads in developing countries, and he said he had never seen anything like what happened here. And he said that he certainly would not have advised the government to do what they did, because it ultimately was so self-destructive. And really, that's what we come down to here. Governments who do arbitrary things for reasons that are not related to public good, you cannot encourage that kind of behavior when you're dealing with international investments. And we would urge you that your award should recognize the fact that the principal purpose of CAFTA is to encourage investment by the part of foreign nationals into the economies of these countries, and that the only way that that purpose can ever be fulfilled is that the countries which receive those investments must comply with the terms of CAFTA. Thank you very much. Oh, I've got one other thing to give you. I apologize. I promised you that I was going to tell you how to operate Mr. Thompson's model so that you would be able to do that. And I'm not going to describe it to you, but there is the last slide in the presentation are the operating instructions for Mr. Thompson's model. Thank you, sir.
Mr. Foster, the claimant has subsisting interests in Guatemala.
I'm sorry, sir?
The claimant has subsisting interests in Guatemala.
Well, they have a presence there at the
Yes.
present time,
Well, they have
yes.
subsisting interests. They're collecting rent, for example.
Yes.
What do you propose is to be done in relation to those interests?
They would have your award would have to include the fact if your award were complete compensation to the claimant, then obviously the claimant would have to turn those over to the government.
Thank you, Mr. Foster. We will have literally 5 minutes break before we have the next closing statement.